More than 20 people with disability and their advocates turned out on the steps of Victoria's Parliament House for this protest today, and they're calling on the Victorian Attorney General to change the law around guardianship so that people under these orders will be able to speak publicly about their experiences. Currently, they cannot. Now, for some context, there are about 12,000 Victorians under guardianship orders. One of the advocacy groups that helped organise today's protest was the Victorian Advocacy League for Individuals with Disability, and its CEO, Fion Skiotis, spoke about the law after the protest. Let's hear what he had to say.
Where there is some need for people to be protected in that way, that can be applied, but the default should be that people are free to speak about their own experiences, even if they were negative. We think that's important because if people are free to expose what they've been through, if there was abuse or exploitation, that can be exposed. In other words, they can blow the whistle.
Guardianship or administration orders are formally put in place by a court or a tribunal, and it is appointing a person or organisation, essentially giving them authorisation to act on behalf of, make decisions on behalf of, or give consent on behalf of a person. Now, people might be under these orders because they are assessed as not having capacity to make their own decisions. And when we talk about people with disability who are mostly represented in this group, it is people with intellectual disability. Now, the Disability Royal Commission held a whole hearing around guardianship, and it did hear from people about the experiences, and they talked about significant impacts on their freedom of movement, their privacy, and also their connections to family and community. Now, in its final report, the Disability Royal Commission handed down a couple of recommendations in relation to guardianship, and it's recommending that supported decision-making be embedded in law and practice, and substitute decision-making only be used as a last resort. So just quickly to explain what those two things are, supported decision-making is exactly that, supporting a person with disability to make decisions about their own life, and substitute is obviously substituting a person in to make the decisions on behalf of that person. So the recommendation is to have common practice for supported decision-making, and only last resort is that substitute to be used. And really, in relation to today, advocates are saying it is unacceptable that people with disability cannot speak publicly if they are under these orders about their own life.